Good morning, everyone. First of all, I would want to thank All India Federation of Tax Practitioners to host this webinar on 3 years of GST. I think it is my privilege and honor today to speak before such a learned audience. And I think each one of you has different experience and the court experience which you have. It is my duty, with humble submission, just to share some experiences and thoughts before such a learned audience. I would today start with a very short story before we go to GST, and I think that story has very much relevance today in this COVID situation. There were two Japanese students who were studying in London Business School. One of them was making the notes, and the other one was just sharpening the pencil. The one who was using making the notes was using this pencil made in Japan. The Britisher asked these students that why is it that you are using this pencil? Because this pencil is not very good in quality. You need to sharpen it every 10-15 minutes, and you see your efficiency, it has gone down because of the usage of this pencil. The Japanese students told the Britisher that if we do not use this pencil, then who else will use this pencil made in Japan? It is our duty to basically promote the products which are made in our country. And hence, the Japanese set an example in everything they do to basically consume first those products which are made in their country. Today, even if we consider the example of a pencil, then Japan is considered to be the country which manufactures the best quality of pencils. So from that time till today, you could see the change. And I think the message is very clear from the top leadership and from everybody that today we have to support our MSMEs. We have to support Make in India. We have to basically rely on everything which is manufactured here in India, and the services should be availed from those people who are based out of India. So moving on to that, I think that was also one of the moot reasons for implementation of GST. Not only globally, we wanted to look that we are in sync with the global policies, but this GST was destined to basically make lot of changes. Of course, this was a revolutionary tax, which is supposed to be one of the most important talked about subject of the recent times. Of course, it is transformational. And if we see the revolution which started from Atal Bihari Vajpayee's days in 1999 when he first announced, various governments changed, and then it ultimately got implemented almost after 18 years by Shri Arun Jaitley ji. Why this tax is considered to be so transformational? Of course, there were a lot of objectives, such as removal of tax cascading, which was the moot point before the GST Council or the governments, that tax cascading should be removed. And hence, GST was designed in such a way that there is no tax cascading. Another fundamental issue was there that the consumption state gets the benefit, and hence the concept of destination based consumption tax system came into play. Let's talk about the tax cascading first. Of course, we feel today that while in full spirit GST was implemented with these objectives of removing the tax cascading or the principles of destination based consumption, few things I think need to be looked into. I will give you a couple of examples. For instance, if there is a project of residential dwelling for students or for working people, which is nothing but for residential purposes, say a hostel or something. Now, if a person takes that property on lease, then there is an issue whether the landlord who would charge it to the person who's into this business, will he be charging the tax, because the ultimate use remains the residential. And the second leg of the transaction, of course, is that it is ultimately used for residential purposes. In such a situation, the ambiguity which arises is whether there would be tax cascading because of the higher input tax costs, which will not be a pass through. This is one example. Another example, you could see, for instance, a publisher, the books have been exempt, not the notebooks, but the books for universities, etc., are exempt from tax. Now, publisher would procure paper, would be printing, would procure ink, and would pay to the authors. Lot of these costs now would actually come to the publisher and would not be a pass through. So I think when we talk about the inverted duty structure, it is, I think, the need of the hour to see whether there is tax cascading due to the inverted duty structure, and if the benefit has to be extended even to the exempted products. So I think those are important aspects which need to be seen. Now, coming on to the destination based consumption principle, GST 3 years back was implemented with the sole objective that the benefit of the taxes should go predominantly and substantially to the state where the consumption happens. And accordingly, a lot of these consumption states where the consumption was high, the import would come from the other states into these states. The collection never dropped. And I think that model really helped a lot of these consumption states, because at the end of the day, they would require more revenue to cater to the larger demands of the population as well. We will go on to the destination based principle in some time, because I have certain comments there, especially with respect to place of provision of services in certain cases. But coming back to the fundamental aspects or fundamental issues related to GST, I think 3 years back when this was implemented, one of the most innovative idea, which I think the entire world observed us following, was with respect to implementation of GST for IGST for interstate transactions. The most innovative and thought out method of tran- uh, imposing tax on interstate transactions came by way of levying IGST, and at the same time, the entire burden with respect to settlement of the transactions between the center and the state was done through the GST network. So, without compromising on the principles of the destination, lot of good hope to the entire objectives of GST. Now, going back to 2016, if we see 2016 and the much spoken and relevant aspect was the destination based consumption system, which got implemented. And I think the global players were watching India. And it was not just the compliance, but these principles which were very relevant. And if we see the ease of doing business, India in 2016 was rated at 130, 130 before GST. And in 2017, India was amongst the top 100. So it clearly gained tremendously after implementation of GST, and it kept on improving from thereafter. 2018, it improved to 77 rank. And as we speak, I think it is very important for us to know that India in 2019 for ease of doing business has been ranked as 63. So from 130 in 2016, we have attained this position of 63 in 2019. So I think fundamentally it appears that the global businesses watching India are basically saying that India has improved tremendously on various fronts. I have some sensational numbers, and I think those numbers would are very interesting to understand that how and where we have moved in these 3 years. If we talk about the GST Council meetings, there were 39 meetings till March of 2020. So, which means there was a meeting on an average of more than one meeting per month in these first 3 years. If we talk about the GST Council meetings where voting took place, there was only one instance where voting took place. And I think we should give due credit to the Finance Minister, Mr. Arun Jaitley, who led it from the front. Today, he is no more with us. But I think the way he conducted the GST Council meetings, the GST Council always reached the consensus. There was healthy debate. And I think this voting also happened after Mr. Jaitley was not chairing the GST Council. So, predominantly, you could conclude that GST Council took most of these decisions with consensus and nothing was forced. If we talk about the amendments in the CGST and the IGST Act, there were 65 amendments in the CGST and the IGST Act, which happened. If we talk about the amendments in the CGST rules, 280 amendments happened by 40 plus notifications. If we talk about the notifications issued under the CGST and IGST Act, there were some 600 plus notifications which were issued. If we talk about the circulars issued under the CGST and the IGST Act, there were 150 plus circulars which were issued. If we talk about the writ petitions disposed of, and wherein my lawyer friends and the entire judicial system has to be praised, there were 1700 plus writ petitions which were disposed of. This number is certainly mind boggling. 1700 writ petitions have been disposed of. And here, I'm not talking about those pending writ petitions which are there on important issues, which are still there. But I think full credit has to be given to the judicial system to basically dispose of the 1700 plus writ petitions all throughout the country. If we talk about the reported AARs, there are 1,000 plus reported AARs which have come for the benefit. I would not go whether most of these AARs today are pro revenue and the absence of the judicial member there. But at the end of the day, 1,000 plus AARs all throughout the country have been disposed of. If we talk about the triple ARs, then 150 plus such ARs have been reported. If we talk about the national anti-profiteering orders, I think still the number is not less. It is 140 plus anti-profiteering orders which have been passed after finalizing of these assessments at the initial level. If we talk about the GST collection, last but not the least, we collected 31.19 lakh crores in the 3 years, and the first year was 9 months. So almost on an average, 1 lakh crore of revenue was collected over the period of 3 years. So I think some of these numbers are very, very heartening, especially if we talk about the writ petitions which have been disposed of, and also the writ petitions which are currently there, the important issues which are currently there. So I think today, uh, moving on from these numbers, I would also want to emphasize the GST compensation cess. We all know that one of the backbone discussion of implementation of GST was to provide the compensation to those states which would or may reduce the revenue due to the implementation of GST. The guaranteed 14% revenue growth was promised to states for a period of 5 years. And I think I have some of those numbers wherein 2.66 lakh crores has been released by the center to the state. And couple of days back also, some 36,400 crore was released so that there is no pendency till February of 2020. Of course, the GST Council today has the power to extend this GST compensation cess to another 5 years or maybe to 2 years or so. But I think only time will tell us what will happen with respect to that extension. Another aspect which I thought is very relevant for this audience is to know about the GST appellate tribunal. Now, state and area benches have been notified. However, they're not functional yet. Soon, it is quite possible that we will have these benches working and our level of work at the tribunal would start soon. So I think there was also the Madras High Court writ petition filed by Revenue Bar Association to strike down various provisions on the following grounds, such as member of Indian legal services cannot be appointed as judicial members. Technical members cannot be more than the judicial members. But I think while these disputes will keep on continuing, the good point for us is that soon these GST appellate tribunals would be there in the states and the area benches. And hence, I think full flow of work with respect to GST litigation could then go on from there on. At the time of implementation of GST, Article 279 Capital A of the Indian Constitution was inserted so as to cast responsibility on the GST Council. And let's look that in these 3 years, what has happened with respect to those responsibilities which were there on the GST Council. So if we see the specific provisions, it says that GST Council shall make recommendation to the Union and the states on. And the first one is taxes, cesses, and surcharges to be subsumed. I think this was more towards the implementation stage, and I think we should give full marks to the GST Council with respect to this element. With respect to the rates and exemptions, the responsibility was on the GST Council to provide the recommendation. I think GST Council can do much more here because rate rationalization should be on the cards. The rates of 12% and 18% needs to be rationalized. We need to have lesser number of tax brackets today so that classification and taxability disputes are addressed to a larger extent. If we talk about the another aspect which was with respect to model GST laws, principles of levy, apportionment of GST levied on supplies in the course of interstate trade or commerce under Article 269 capital A, and the principles that govern the place of supply, I think the GST Council had role to play at each stage, at the implementation stage and even the ongoing stage. And today, we know for a fact that apart from all of these items, there is one important element which is with respect to the place of supply, which needs to be addressed. Place of supply needs to be addressed so that the destination based consumption principle comes into full flow in spirit as well. And hence, things such as place of provision for intermediaries need to be looked and recommended by the GST Council in this stage after implementation. If we talk about the threshold limit of turnover below which the goods and services may be exempted from goods and services tax, I think it was at both the stages, at the implementation stage and the stages thereafter. I think GST Council has done a good job to rationalize those exemptions, and I think full marks should go to the GST Council. When we talk about the rates, including floor rates with bands of goods and services tax, this was also to be implemented not only at the implementation stage, but also in the ongoing stage. Any special rate or rates for a specified period to raise additional resources during any natural calamity or disaster. I think the recommendation to this aspect is very, very important. We have seen that, the country today is facing this pandemic situation. And I think there is a GST Council meeting which is scheduled on cards very soon electronically on 12th of June. And it is hoped that these rates are reasonably put across after appropriate discussion. It should not happen that what happened with respect to alcohol, that 70% of the cesses were imposed on sale of alcohol. If the rate is such exorbitant, then I'm sure it will have to pass the test in the courts. And I know it may be a fiscal decision, it could be a fiscal policy, which is with respect to rates. But I think any exorbitant rate on supplies, especially the essential supplies, would be tested in the courts. So I think GST Council in the next 1 week or so will have a very, very important role to play with respect to these special rates in times of these pandemic situations. So last but not the least, the GST Council was also given the responsibility to get petroleum and petroleum products within the GST purview. The GST Council was to recommend the date on which the goods and services to be taxed on all of these five products has to be included within the GST purview. That has not happened, and I think it is the right time now that we get into these details. That when and at least the announcement should happen with respect to the recommendation of inclusion of these petroleum products within the GST regime. So, if we now take a step back, that pre-GST taxes which are still in force, apart from customs, what are these taxes which are still in force? So, to conclude, central excise on petroleum and tobacco products, VAT on petroleum and alcohol, and state excise on alcohol. So, predominantly, it is alcohol which is out. constitutionally we can't impose GST on alcohol, so that's absolutely okay. But I think as far as the central excise duty is concerned, which is there on petroleum and tobacco products, I think that needs to be looked into so that these come within the purview of GST and there is rationalization to that extent. I'm not concluding here that what should be the amount of tax. Of course, there that decision has to be taken by the GST Council. But I think it's very relevant that inclusion of these happens within the GST purview. Another very important aspect is with respect to the National Anti-Profiteering Authorities. And as I mentioned, there are more than 140 such investigations which have been closed by finalizing of these orders. Most of these have gone to the High Court because we know for a fact that there is no appellate mechanism with respect to the order finalized by the National Anti-Profiteering Authority, which means what? As lawyers we have a lot of responsibility and opportunity. Responsibility so that we are on the right side, so that the benefit passes on to the ultimate consumer, but at the same time the businesses should not be burdened with some unreasonable numbers. Today we know that the quantum of profiteering needs to be determined for each and every period and for each and every product. So if there is no methodology or mechanism, then the challenge remains for the business to determine the quantum of such profiteering. We should also not forget that anti-profiteering provisions were to be implemented for 2 years in the beginning at the time when it was proposed, and it was constituted in November 2017 to be implemented to continue till November of 2019. Thereafter, it got extended by 2 more years. Now, the transitional phase from the earlier regime to the GST regime is still understandable that there should not be any sort of or element of anti-profiteering in the initial couple of years. But once this extension has happened beyond the initial thought of period of 2 years, there needs to be full rational and objective of that extension to happen. And I think it will soon happen that even this extension will have to cross the barrier of constitutional validity in the courts. Few other highlights, if we see, of these 3 years, surprisingly, and you all would acknowledge this, that the number of arrests which have happened due to circular trading issues and bogus invoices under the GST regime, tremendous. I think the good part is that the system could track a lot of such lapses. The bad part is that in few cases where imprisonment or imprisonment happened, that was not very relevant because there was no leakage of tax. So I think there needs to be a balance for such things. Of course, the intent here is not to evade tax, but in case there is no evasion of tax, can be person sent to jail for a situation wherein there is no evasion of tax for an offense which is mentioned under the GST. So the number of arrests which have happened under the GST regime are significantly higher than any other taxation system which we have seen in the last 40 to 50 years. If we see the real estate sector, I think the full marks should go to the government and to the GST Council to basically think about all of these problems which are now cropping up and are being faced by the real estate sector. We have seen that the provisions got revamped in April 2019 and January of 2019. I'm not saying that there are no issues as of now. There are a lot of issues with respect to joint development agreements and transfer of development right and reversal of credits and block credits. But I think the endeavor is to move in the right direction. And from that perspective, I think some action happened in 2019, but yes, there is much scope to do much more. If we talk about the establishment of state-wise AARs leading to conflicts to be resolved after formation of the National Appellate Authority for Advanced Ruling, I think that's a good thing which has happened. The inconsistency of decisions between two AARs could also be addressed. So I think which is a very, very welcome move to happen in these 3 years. But if we see the transitional issues, there were a lot of writ petitions which happened because of the transitional issues of the erstwhile taxes coming into the current GST regime. And we have all seen that the courts were burdened with a lot of such issues on transitional credits. If we talk about the court's intervention, and before I go on to the court's intervention, I think today it is very important for us to understand that in this pandemic situation, in this lockdown situation, the Supreme Court has led with example. And the Supreme Court is very clear that we need to ensure that justice is not derailed. So when it comes to urgent matters, there are hearings which are happening very, very seamlessly with respect to the urgent matters. When it comes to non-urgent matters also, there are clear guidelines which have come. So we will come on to that in a moment. But I think as a part of the judicial and the legal system, today it is a proud moment for us that we have used these innovative mechanisms and ways to ensure that justice is not derailed. Now, if I were to pick the three most important writ petitions which got addressed and those issues, I would want to basically take three such matters. The first one was with respect to the advance authorization and the export benefits which were to come from the pre-GST regime to the GST regime. These advance authorization benefits were curtailed in in the GST regime, and there were various writ petitions which I was arguing in Delhi High Court just to ensure that this benefit from which was promised in the earlier regime gets passed to the exporters, to the Indian exporters under the advanced authorization licenses in the current GST regime also. While I know it's an admitted fact that equity jurisdiction doesn't work for tax matters, but I think today equity has an important role to play even in the tax matters. I think the courts acknowledged very clearly that this benefit im- needs to be passed on, needs to continue. The working capital issue is a big problem for the Indian exporters. And in case of Narendra Plastic versus Union of India and others, this this issue was addressed by Delhi High Court by way of an interim order. Then there was finality with respect to that order, and thereafter there was an amendment which happened so that the benefit of IGST exemption is extended with respect to the advanced authorization license holders even after a particular date. The second part of the problem was the imposition of the pre-import condition. And while the first battle with respect to extension of this IGST benefit on imports got extended after the favorable order of Delhi High Court and the interim order and the final order, and thereafter the SLP also got dismissed in the Supreme Court. The issue was that the amendment which happened imposed a pre-import condition to allow that benefit. Thereafter, plethora and dozens of writs were filed in multiple courts. And I remember that I argued this matter in more than 8 courts to on pre-import condition. And Gujarat High Court was bold enough and pragmatic enough to pass a detailed speaking order with respect to pre-import condition, wherein pre-import condition was held to be unconstitutional or ultra vires the foreign trade policy, and the matters have now gone to the Supreme Court by way of an SLP by the revenue. So I think this was a very, very important and a landmark decision with respect to the pre-import condition, and thousands and thousands of Indian exporters would have got benefit from this entire writ petition with respect to the pre-import and also with respect to the initial disputes when this benefit was not transferred to the Indian exporters who were holding advanced authorization licenses. The second landmark decision, if I would were to see with respect to these 3 years, is constitutional validity of ocean freight when tax is being imposed as IGST on imports made on CIF value. I again had the privilege of arguing this issue in various courts across country. Gujarat High Court again, gave a detailed order with respect to the ocean freight. And here also the controversy was with respect to the taxability or applicability of IGST on a transaction which is basically between two non-residents. Today, under the service tax regime, it is very clear that the service provider and service recipient are defined. Now, an importer in the country who's not privity who does not have a privity of contract with respect to this freight, can that person be deemed to be the service receiver with respect to that freight element and be subjected to tax? If, for instance, the freight is to be taxed, then why not insurance on such transactions should also be taxed when those transactions are between two non-residents? So I think in these 3 years of GST, we have seen such important issues which will now, from now on, be always relied in the years and decades to come. Third decision which I feel which is very very relevant in these 3 years is the recent decision of Delhi High Court in case of brand equity versus Union of India. The issue here was with respect to the transitional credit, and I again had the privilege of arguing this point before the court, that whether this time period prescribed in the delegated legislation is directory or mandatory. We know for a fact that with respect to the technical glitches, there were extensions. With respect to the technical glitches, there were benefits. But in this case, we were very, very honest before the court that we actually forgot to take the credit. Now, if we forgot to take the credit, then there is a period of 90 days which is prescribed in rules. Today, is it possible for me to avail that credit after the period has been lapsed as far as I am concerned? The court went ahead to go into a lot of details, such as, is credit my vested right? Are the timelines which are prescribed in the delegated legislation directory or mandatory? In fact, the court very, very clearly held that these timelines which are prescribed are not mandatory. In fact, the court went ahead to say that the benefit of this uh, decision should not be restricted to only the petitioners. And that's why today this decision has become one of the most talked decision in these 3 years. The court has very, very clearly told the and directed the respondents that they should publicize this order so that the benefit of this order is not restricted to the petitioners, but the benefit goes to everybody who would face such a situation. So, from that perspective, it is indeed a landmark decision. Another very relevant facet of the decision was with respect to the applicability of the period of 3 years, which the court borrowed from the Limitation Act. The court felt that this 90 days period is not the correct relevant period which should determine the time limit within which I should take the benefit. The court clearly said that it should be the period of 3 years borrowing from the Limitation Act which should give this benefit. Now, moving on to the other pending writ petitions, we know for a fact that there are writ petitions on transitional credit on pre-GST stock beyond 1 year. There are contradictory decisions of Gujarat and Bombay High Court. And Delhi High Court, in the meanwhile, has given an interim order with respect to such situations. Of course, it will be decided by the Apex Court now. ITC accumulation on account of restriction of rebate benefit and exclusion of transitional credits for computing net ITC. The matter has been almost concluded in Gujarat High Court. Again, this is expected to be a landmark decision. With respect to the taxation of intermediaries, the matter has been concluded in Gujarat High Court. And this decision, if it comes whatever way, will lay down a lot of principles with respect to taxation and the place of provision and the concept of the destination based consumption services. So I think again this will be a very very relevant decision, and if it comes in this period, I think it will be handy and useful for a lot of our Indian intermediaries who are exporting these services. With respect to the block credits, we know for a fact that there are dozens of writ petitions which are filed in different courts with respect to the block credits, with respect to section 17.5C, 17.5D, and 17.5H. And I think with respect to block credits, again, the industry is watching that, what should be the outcome of the court. Of course, there is a safari retreat decision which has now gone to the Supreme Court. But I think a lot of jurisdictional high courts are also addressing these writ petitions, and most of these would now be heard by the Supreme Court and will be decided by Supreme Court. Denial of transitional credit on capital goods procured by units in exempted zones, the budgetary support issues, all of those issues such as entertainment tax and these benefits which were given to a lot of these units in the earlier regime are again really, really interesting ones to see. With respect to the cesses, education cess, she cess, and SWS controversy for SEIS and MEIS schemes are again relevant writ petitions which will soon be addressed by the courts. There are a lot of open issues also which are relevant today for discussion purposes. Uh, for instance, what happens in case of a donation of ventilator mask given for charity purpose, whether the credit can be taken in such a situation. And I think what is very, very relevant is the wording of section 16.1, wherein the provisions clearly say that there has to be used or intended to be used in the course or furtherance of business. And that needs to be looked into. And my view is very, very clear that credit cannot be denied for such usage. Another issue which is now coming up is with respect to the health insurance. We know for a specific reason that these health insurance services are treated as block credit unless until there is some specific guidelines from the state authorities. So what happens when this health insurance is now taken by companies for COVID-like situation? And I think the benefit of credit has to be given to the corporate world for these health insurance services, because most of the state governments are now providing these guidelines, which have come in specific states. That I think based on that, this benefit has to be extended. Another very important aspect with respect to this pandemic situation is with respect to damaged goods and whether credit should be reversed on damaged goods. We know for a fact today that a lot of wholesalers, retailers, and even factories are facing this problem of lockdown, because of which the existing stock, such as footwear, bags, and so on and so forth, would be damaged. The provisions today say that as per Section 17.5H of the CGST Act, the credit would be reversed with respect to the goods damaged. Now, if that happens, I think it will be a big pain for the industry. In this tough time, even the industry is facing the problems of bad debts. We know for a fact that the taxation system is such that at the time of raising the invoice, the supplier will have to pay tax. Now, in case there is any bad debt which happens, not only the supplier loses with respect to the consideration, but also becomes out of pocket and gets the burden of the tax which he has to pay. So the benefit which has now been given by way of this ordinance which has been passed is only with respect to the advance of services and the goods return. There is no such benefit which has come with respect to bad debts. And I think that's a thinking point which needs to be analyzed, that what should be the treatment with respect to such bad debts. Credit reversal on account of failure to pay to the supplier again is a subject matter of debate and dispute in such a pandemic situation now, because if I'm not able to pay to my supplier within 6 months, there is a need for me to reverse the credit. So can some sort of mechanism be planned so that that reversal is not there? The much debated and talked about concept which has now come up and which is keeping most of us also busy is with respect to force majeure and frustration of contracts. Force majeure and frustration of contracts would be relevant not only for the rental agreements but also for contracts of supply. We know for a fact that to address this problem of force majeure, There are two very important and essential elements which need to be seen. One, this being the contractual problem, we need to see how is force majeure defined in the contract. Once this situation of COVID-19 falls within the definition of force majeure, which is defined in the contract, I think there is a need to look into the consequences when this becomes applicable. So, for instance, if pandemic situation like COVID-19 gets covered, or this situation gets covered by way of the point that the premise becomes unfit for use, then the force majeure kicks in, but then the contract has to specifically and categorically talk about the consequences also. What happens once this force majeure kicks in? Whether determination of the agreement happens or whether there is an option of not paying for this lockdown period, those needs to be looked into as far as the rental contracts are concerned. When it comes to the contracts of supply, of course, force majeure will have a wider applicability, because if there are some time bound supplies which were to happen and the deliveries with respect to these procurements were to happen within a stipulated time, force majeure will certainly come into play, because some of these actions on my part are completely out of my uh, uh, power. And in such a situation, the force majeure would come into play to determine whether I did my best to ensure that the supply happened. And if there was a late delivery, then by how much time was the late delivery? What was the lockdown period where the supply was to happen, and so on and so forth. Post sale discounts in this COVID like situation today, there are a lot of these discounts which are to be passed on. We know for a fact that discounts become deductible only when these are predetermined prior to the supply. And hence, it becomes very important for us to today analyze all of these contracts where discounts are being passed on, how the documentation with respect to these contracts are happening, or are there appropriate addendums which are put in place to address this problem of post sale, post supply discount, so that GST is levied after deducting this discount element. And even if this discount is for a specified period, it needs to be documented at this stage so that the benefit passes on to the businesses. Delay in refunds and incentives has been much debated today and is a big problem across various sectors. And I think if there is an unreasonable delay, then the right mechanism again is to approach courts and to ask courts intervention with respect to these delays. I thought I would also put certain points with respect to the representational thoughts, whether we can today think of shifting of point of taxation from billing basis to the payment basis. We know for a fact that in a situation like this today, where the entire economic slowdown is there, the GST is levied at the time of raising the invoice. If we go back to the earlier regime, and at least this benefit is extended in the COVID like situation or till the time the economy revives back, it will be important to shift this point of taxation from billing basis to the payment basis, so that it also addresses the problem of bad debt, and also the businesses are not out of pocket. Supply of protective items for COVID-19 should be zero rated. I think we have spoken about the tax cascading effect when there is an exemption, and this benefit of this benefit of credit is not passed on to those products which are essential and which have got the exemption. I think zero rated is the best way for some of these products in this situation. Refund of accumulated unutilized credit refund of last 3 months. There are a lot of businesses which have unutilized credit, and that credit is there in my credit ledger. If there are provisions today that in this situation you could basically get the refund of those taxes as well, I think the businesses will benefit from that. Liability to pay under reverse charge using ITC. Even a lot of our clients who pay tax under the reverse charge for these services, such as the legal services, have to pay tax out of pocket. But in case they have credits, so at least can for some time, is it possible that the liability such as on the services rendered by the advocates, is discharged by them using credits. Of course, once they discharge this tax using credits, they would not be allowed further credit, but they would not be out of pocket from the cash perspective in this tough situation. A refund on capital goods and services under inverted duty structure. And I think inverted duty structure needs to be looked into because there is denial of services with respect to the refund under the inverted duty structure. While here again, the Act says that Act does not provide any restriction with respect to the services. It is the delegated legislation which, by way of a formula in net credits, deny the benefit of this credit on input services. So that needs to be looked into as well. IGST exemption on imports of ventilators, surgical masks, PPE kits, and testing kits will have to be looked into whether these exemptions can be given. And of course, we need to see which all elements today have tax cascading effect. Either the government should come out in this next GST Council meet to address this problem of inverted duty structure, tax cascading, and at the same time, they need to look into rate rationalization. The rate rationalization should happen in such a way so that essential commodities are not taxed at a higher rate. There are lesser number of rates today, and also the GST collection doesn't significantly dip down. So that ends predominantly what has happened in these 3 years, some of these major writ petitions which were filed, some of these representational thoughts, and some of these open issues from the COVID perspective. Now, I would move to the most important topic of today's webinar, which is the virtual courts. Now, we know for a fact that a lot of this discussion is happening whether these virtual courts are good or bad, whether technological use is good or bad, whether this is essential today or it could be delayed. Today, as we speak, there is some news that even Madras High Court, certain judges have uh, contacted this COVID 19 and they are tested positive. In this situation, I think it is very important as advocates that we lead by example to set the tone in the right direction. परिवर्तन ही दुनिया का नियम है. परिवर्तन के बिना कुछ नहीं हो सकता है. I think change is the only constant. There are lot of resistance which happen, and rightfully so. I'm not saying whether that is right or wrong, but today it is important that we adapt to the new system. Let's be realistic. Let's understand that this situation of COVID 19 will not vanish that easily. We have to be very, very careful. Now, if there is a complete shutdown on the litigation process or the business, all of us, not only the advocates, but a lot of people who are attached to us may face very, very difficult times. Even the litigants would feel that justice is derailed. So I think it is very important that we understand that what Supreme Court wants to be implemented, and how we as advocates today assist each and every person, each old and young, those people who are in court and so on and so forth, to ensure that the use of technology comes into play. Now, if we see the initiative which has been spearheaded by the Supreme Court, following directions were issued by way of suo motu writ petition by Supreme Court, which mentions that all high courts shall ensure functioning of the judicial system through use of VC technologies and shall decide the modalities for use of VC technologies. District courts in every state shall adopt VC technologies prescribed by the appropriate high court. Courts shall make VC facilities available for those litigants who do not have access to these facilities, including the appointment of advocates as amicus curiae. Till high courts frame rules in this regard, VC technology shall primarily be used for hearing arguments both at the trial as well as the appellate stages. Evidence shall not be recorded using VC facilities except with the parties' mutual consent. Now, even if we see the concept of live streaming of court proceedings, this has been tested in various courts in India, including Bombay High Court, Calcutta High Court, and Kerala High Court. There is a clear direction that with this, every single high court in the country has today started conducting hearings virtually of urgent matters, which is a big sign. And I think it is the proud moment for each one of us who's part of this judicial system to basically witness that each and every high court in the country today has started conducting hearings virtually. And if the courts have started that, if everybody in the court is also adapting to this new norm today, which I think we'll have to be realistic and pragmatic, will be there in the near future, then I think it is our duty as advocates to train our juniors, to train our seniors, to train ourselves, to train our support staff, to train everybody in the court to update with respect to this technology. Because if this technology use is not made today, then I think we ourselves will be out of relevant business. Delhi High Court has started hearings, in fact, for non urgent matters also. And even tribunals, quasi judicial forums are slowly following that. So I think from that perspective, it is clearly evident that we need to move in a particular way so that we ensure that we remain in the business of providing these services to the most needy people and justice is not delayed. Now, of course, there are certain challenges. I'm not saying that there are no challenges, and various forums, bodies, associations have highlighted those challenges. I have listed down some of these challenges with respect to the virtual hearings, but I don't think that any of this challenge is a challenge which cannot be addressed. And hence, it is important for us to understand these challenges and also try to find out the way by which these challenges could be addressed. Advocates cannot rely upon any documents other than those that have been filed. This is as per the rules, which may be a challenge because at times it is relevant for you to basically rely on certain document which is not part of the paper book. But I think the courts will be very, very really, lenient in the days to come. And if there is any such document which needs to be placed on record, I think there will be some sort of flexibility. Principle of open court hearings. Article 145(4) of the Constitution has not been followed is a challenge today. Hearings to be made accessible to the public and media. That is the challenge which has been today posed, and the question has been raised with respect to this. And I think in this environment, when we are living in such a dynamic environment, it is very important for us to understand that everybody is adapting, but it is taking some time. Now, even with respect to the live streaming, I mentioned that Bombay, Calcutta, and Kerala has already started that testing. Now, if that happens, I think this challenge will be addressed as well. Physical presence of under trials, cross examination of witnesses. There is, of course, a challenge with respect to body language, facial expression. And we as advocates know a lot of time we take these pauses wherein we would want to see the facial expressions of different parties, including those of the learned judges. And I completely understand that it is an important sign for all of us to take a pause at relevant times while arguing the matter. Of course, that remains a challenge, but I think we will have to live with that or probably adapt ourselves to address that issue also when these virtual hearings are happening. Possibility of the other person being coached off camera or reading from a hidden script cannot be ruled out. That's absolutely okay because even in the court, even if the advocate is not very well prepared and reads from the paper book, I don't think court would say that you are not supposed to read from the paper book. It may not reflect well for sure, but I think when technology is being used, this is bound to happen. There will be some challenges which would be there with respect to this aspect as well. Confidentiality, I think that's very relevant. Privacy policy of third party apps, threat of interception, posting of confidential documents is a risk. I think that is a real challenge that can be addressed by using robust technology and making the law very, very strict for any such infringement which happens by way of piracy, etc. I think that could be addressed. It is not that it cannot be addressed. Stable internet bandwidth, widespread availability of efficient laptops and smartphones, that is not a challenge while it has been largely spoken and debated, but that's not a challenge. Today, we are actually living in an environment where all of this is available. And we today also buy expensive books. We know for a fact that our library has the most expensive books today, because if that is important, then I think even the new technology is important. The new laptops with all facilities are also important part of the business. So I think that's not a challenge. I was also doing some research and spoke to a couple of people about these different challenges. And we know for a fact, and we have seen it ourselves in court, that when the arguing counsel is arguing, the junior would provide some hint by way of a chit, or would give some sort of a hint by saying something in the ear. And I think that also has been hinted by a lot of people as a challenge. People say that hints to an arguing counsel, which is very, very possible to give in the court, is very difficult in the virtual hearings to be given as hint. But I think we Indians are very innovative when it comes to such things also. And I will not be surprised when the arguing counsel will have two different mediums, one before the judges through the laptop and the other one with the AirPods, so that the hint from the junior can come, or some sort of a pop box in the laptop where a personal message could come. So I think that hint, while it is interesting, it will be seen that how it is also addressed in the days to come if these virtual courts continue. So I think it's very important for us to basically also see the global scenario. If India has to emerge and adopt as the global superpower, today we need to see the best practices in our profession which are being followed internationally. And if we talk about the US Supreme Court, US Supreme Court is hearing oral arguments via telephone. So it's not, so they have basically gone significant way ahead, and they're saying that this problem of bandwidth, laptop, etc., while these may or may not be relevant, they have gone ahead to hear these oral arguments over phone. So I think, which is mind blowing, and which is very, very surprising, to learn. Uh, if we talk about courts in Germany, courts in Germany continue to operate physically, but the federal court is close to outsiders. So they have taken that stand. If we talk about the UK, from where India borrows its open courts principle, has been broadcasting court proceedings during COVID-19 pandemic. Its emergency legislation, the Coronavirus Act 2020, accommodates the open court principles by making specific provisions for broadcasting and recording court proceedings conducted via video conferencing, so that public and media participation is ensured. So I think if we were to pick the best points in emergency matters, what US has been doing to hear matters over phone, what UK has been doing to broadcast and record such court proceedings conducted via video conferencing, is a beautiful example. If we see countries like even South Africa and Ugandan judiciary is using Zoom. So I'm not very comfortable with Zoom. There are a lot of problems with respect to Zoom, and there are challenges which could happen. But still, if you see these countries, they are using Zoom because they want to use this technology. While New Zealand is using Microsoft Teams for virtual hearings, which is a much safer platform. So even if we see these countries today, they have adopted themselves to use this new way of conducting court hearings. There are certain grievances which have been raised by the Supreme Court Advocates on Record Association. I would not get into too much of details, but what their grievances are. They are basically saying a request to resume physical hearings from July. We will have to see whether that is realistic. I think the courts will be pragmatic enough, especially after seeing the situation what has happened in Madras High Court with respect to this COVID-19. test being positive for few judges. Staggering working of courts has left lawyers in severe financial crisis. I understand that, and I think that's very relevant for us also, so that we adopt this new technology and the business goes as usual till whatever extent. Technical glitches is happening in virtual hearings. 95% lawyers are not comfortable. That data has gone from this AOR association to the Supreme Court, and I that's very relevant for us, because if 95% of us are not comfortable, I think we need to get into that comfort zone as early as possible. Even if we, and I still remember that I I have given a beautiful presentation in Orissa where I think there were 500 lawyers who were present, and that was a different feeling altogether to speak before a large audience of advocates in huge numbers, such as 500. But today, even if you see us, how we have adapted, today this webinar is happening on YouTube Live, and which gets recorded, which would be seen by people in the days to come, in the years to come. So I think we are adapting every day. And if adaptability question of us goes high, then I think the judicial system will continue the way it always continued. So I think when this grievance goes that 95% of the lawyers are not comfortable, I completely respect, that of course we may not be comfortable because we are used to do a lot of things, but at some point of time we will have to move out of our comfort zone. We will have to adapt very quickly, because let's be realistic, it's not going to end in a week. It will be with us for quite some time. And if we have to ensure that the justice is not derailed, then I think it is our responsibility to adapt ourselves. Lawyers unable to present effectively, not well equipped with computers. I think as far as the problem of computers is concerned, that is in our hand, that can be addressed. And as far as the lawyers are unable to present effectively, I think we all of us are learning every day. I, we all have argued at some point of time the first matter in court, the district court, the high court, and the Supreme Court. At that stage, also, we were uncomfortable. Today, when it comes to virtual hearings, also, it will be the first time. There will always be a first time to do something. But the faster we become comfortable to the new system, I think the faster we will be able to help the entire economy. There were certain suggestions, cases to be heard in shifts, which is a good suggestion. Lawyers should compulsorily leave the courtroom once his her case is over, and I think they're talking about the physical courts coming with some suggestions, which is important with respect to sanitization, etc., etc. But I think most of these suggestions are with respect to these cause lists being divided into batches so that lesser number of people are there in the courts physically, library and canteen to be shut, and so on and so forth. Now, if we talk also about the virtual hearings by CSTAT, there are CSTAT procedure rules which have been amended. Even under the revised procedure, the filing will have to be made physically at the relevant CSTAT registry. Summary of some of these key changes are as follows. President of the CSTAT has been empowered to notify e-hearings via video conferencing. Soft copy of the documents, appeals, cross objections, applications, paperwork, etc., shall be optionally filed in two pen drives in addition to the physical copies thereof. Memorandum of appeal, in addition to the declaration required presently, should clearly mention the mobile number and email ID of the parties of the appeal. Further, it shall set out the distinct headings, the statement of facts, the grounds of appeal, grounds of cross objection, be consecutively numbered and have double text spacing. Appeals of cross objections or the application filed with the CSTAT shall specifically declare and verify that the soft copies of the documents are true copies of the original physical copies. So I think with these CSTAT procedure rules also getting amended, we feel that even the CSTATs would come into these virtual hearings. There is some resistance, which I learned is there from bar associations in different cities with respect to these proceedings virtually. But I think we need to be very, very pragmatic here because virtual courts may become a new norm, at least for the near future. So I think if we adapt ourselves well in this environment, then I think all of us will be very, very happy as far as our profession is concerned. So, with that, I broadly finish my presentation with respect to the highlights which has happened in these 3 years of GST, from the implementation stage, from the courtroom till the virtual courts. All of us have seen these changing times, the transformational change with respect to GST, the new laws getting interpreted and being addressed in the writ courts. With that, I would want to end my presentation here, and I would want to thank all of you for attending this webinar. And I would also specifically want to thank the organizers of the All India Federation of Tax Practitioners West Zone, who have basically organized this and have invited all of you for this webinar. In case there are certain questions, I could not see much of these questions. These questions could be posted on this link, and I would try to address these questions after I see these questions, and you could read the answers in this live chat later on. But as of now, because there are no questions, I would take your leave, and I would wish you a very, very happy weekend. And I also wish you to be safe, take all precautions, and spend most of the time with your family. Be safe, be healthy, and keep thanking God for what God has given us. Have a good day.